Hey, this is Adriana in Long Beach, and I'm coming at you with a video titled, Why Can't Black People Support Black Business? And in this video, I'm going to be going over some of the finer points of the Fearless Fund lawsuit and the Hello Alice lawsuit and their implications. Because when Black people try to invest in Black business, they get sued. Okay, so let's start. So first up, what is Hello Alice? Hello Alice is a for-profit company that matches small business owners with financing to help the business grow. That could be loans, grants, credit. It's an online platform. It was formed by Elizabeth Gore and Carolyn Rotz. I do not think that this is the Elizabeth Gore that is related to Al Gore. In any case, it's based out of the Bay Area. They've helped 1 million entrepreneurs so far. They're valued at $100 million. The type of businesses that they assist are like individual entrepreneur type businesses or maybe family-owned businesses. For example, the lawsuit came when they were managing a grant for Progressive Insurance, and the grant was to help the business owner purchase a qualified vehicle. So you are a gay dog groomer and you want to expand your business by getting one of those mobile dog grooming trucks. That's the level of business that they assist. And they are a mission-driven business, and they say out front that they want to help businesses run by typically underrepresented people from underrepresented groups, disabled people, people of color, LGBTQ people, women, that type of thing. So that is Hello Alice. So what is the Fearless Fund? The Fearless Fund is run by 3 African-American women, co-founders, and they are on a different level. They are helping companies, already established companies, get financing that they need to scale up. And they give grants. That the grant that they're being sued about is called the Fearless Grant. And they cooperate with big companies like JP Morgan Chase and other big financial institutions to get financing to pass through to these grants, to get financing to grant this grant money. So as I was saying, Hello Alice was managing a grant that Progressive put out there. These Fearless Fund does its own grants and manages those grants, but it's its own grants and gets financing from the JP Morgan Chases and from VCs to finance the grants. So you have to be a C corporation, and you have to have at least one Black woman who is I don't know if she has to be a majority stakeholder, but she has to have a major stake in the company. You have to have a 5-year business plan. Like, this is for, you're already an established company. If you're applying for the Fearless Fund grant, you just need, it would just be helpful to get $25,000 in grant money to help you scale up. So they deal on a bigger level, and their scrutiny seems to be, at least for the Fearless Fund grant, a little more rigorous. It's not that Hello Alice is not rigorous scrutiny, but the level of business you need to be at to apply for the Fearless Fund grant, you need to be a little bit bigger already. So that is Fearless Fund. Okay, so let's get into the background of the Fearless Fund lawsuit. I'm going to be referring a little bit to my notes here because there are some details that I really don't want you to miss. So in August 2023, the American Alliance for Equal Rights sued Fearless Fund, and the suit was based on an allegation that Fearless Fund was breaking United States Civil Code 1981. That civil code was brought into the law after Reconstruction to help newly freed slaves get their come up by making it against the law to discriminate on the basis of race in contracts. So the American Alliance for Equal Rights was claiming that the businesses receiving the grant had to sign a contract. So if the only people who were eligible to even get the grant are African American, Fearless Fund is discriminating on the basis of race in contracts, therefore violating a Civil Code 1981. So it first went before the United States District Court for the Northern District of Georgia. The judge in that case was Judge Thomas Thrash. And the AAER, the American Alliance for Equal Rights, said, while this is being adjudicated, Judge, we want them to stop giving grants to Black women because it's illegal the way they're even doing it. So stop their grant program right now. No more money going out. And Judge Thrash looked at the case and he said, okay, look, I am not going to give you an injunction, even though from the looks of it, the grantees do sign a contract and it does kind of look like Fearless Fund is in violation of 1981. That said, it also looks like Fearless Fund could make a pretty good defense using the First Amendment, saying, it's our money. Money is speech. We want to speechify about how Black women don't get enough VC money, and that's why we're giving grants. Don't step on our free speech. That's our First Amendment defense. Judge Thrash says, I think this is a pretty decent defense and that they might prevail, so I'm not going to give the injunction. So the AAER appeals, and they appeal to the 11th Circuit Court. And the 11th Circuit Court says, we're not going to get into the merits of the case at this time, but it does look like Fearless Fund is having the grant recipients sign a contract. And it does, and it doesn't really look like they have a decent First Amendment defense. And I'm going to get into why that is in a second. So we're going to grant the injunction. Fearless Fund, you stop giving out that money to Black women. So that was the background. And that happened in September of 2023. That's when the 11th Circuit Court 3-judge panel made that decision. It was a 3-judge panel, but catch this, one of the judges really wasn't down for it. He was overruled by the other two, but he really wasn't down for it. And we need to get into why. So I want to point out something really important, and this is specifically to those Black people who say, Biden hasn't done shit for me. I'm not voting for him because he made all these promises and my life has not gotten better. Plus that I don't like what he's doing with Gaza. I agree with you. I'm tired of it. I'm tired of the promises not being kept. I'm tired of my situation not getting better. I don't have the support for Biden that I did in 2020. I'm looking at candidate Kennedy. I'm maybe even looking at candidate Trump. Or maybe I'm not looking at candidate Trump, but I'm either not going to vote for president at all, or I'm looking at candidate Kennedy. You need to really pay attention to what I'm about to say next. I want to tell you that Judge Thrash from the United States District Court of Northern District, who did not give the injunction because he thought, yeah, they got a pretty good First Amendment defense. He was a Bill Clinton appointee. Judge Wilson, the judge who got outvoted on the 3-judge panel for the 11th District Court, he was a Bill Clinton appointee. The 2 other judges on the 11th Circuit Court were George Bush appointees. Let me specifically get into why Judge Wilson nearly went apoplectic on this case in his dissent. Because, I don't want to mess up his words. Judge Charles Wilson dissented, concluding that only racial minorities can bring claims under Civil Code 1981, noting that 1981 was passed to protect the rights of freedmen following the Civil War, not to frustrate efforts to narrow the gap in venture capital funding caused by centuries of intentional racial discrimination. So he was offended. Judges can't just come out and say, nigga, what? They got to say it in a very legal, very professional way. But you can tell that he's apoplectic, that the American Alliance for Equal Rights is using a law that was meant to help the progress of Black people in the United States after the Civil War to thwart the progress of Black people in the United States in 2024. Like, the man's not happy. Again, elections have consequences. Trump has stuffed the courts with these right-wing judges. But even before Trump, George Bush, these two white ones, were appointed by George Bush. When you say Biden hasn't done shit for me, think about who Trump would continue to appoint to the courts. Think about this Fearless Fund lawsuit, which is keeping owners of Black businesses who are really trying to grow their business so that they can be bigger and probably hire more employees, and probably a lot of those employees would be Black people, is being thwarted by twisting a law that was meant to help freedmen. Elections have consequences, and you need to really think on that before you decide that you're going to leave the top slot for POTUS blank on your ballot because you're mad that Biden didn't do enough. I'm mad at Biden too. But I'm looking at the whole situation. Legislative, judicial, and administrative. And you need to look at the whole situation as well. One more point I want to make before I go on to the next slide. The whole predication of this case is that Civil Code 1981 prohibits discrimination on the basis of race in contracts. Now, what has that got to do with a grant? Let me tell you why the 11th Circuit Court has decided that the Fearless Fund grant includes the grant recipient signing a contract. Because when a business gets the grant money, the owner signs a contract, or the applicant signs a contract, giving the Fearless Fund permission to use their idea, name, image, and likeness for promotional purposes, and agree to indemnify Fearless and to arbitrate any disputes that might arise. So, I'm a Black baker, and I'm trying to get my cakes and cookies into Ralph's, into all the Kroger stores. But in order to do that, I need to build out my cookie factory. So I get a grant and I sign a waiver saying, oh yes, you can come to my factory and take pictures of me, and you can use it on the Fearless Fund website and in the Fearless Fund brochure, saying, look at this Black business person we helped and look how great they're doing. And if another cookie company says he stole our recipe and the only way he was able to do that is that he got that $25,000 from Fearless Fund, we're going to sue him and sue Fearless Fund for supporting him, that I will pay out of my pocket for a lawyer to defend the case and defend you. I'll indemnify you. That is the entirety of what they're considering a contract. Not that the Black baker has to give Fearless Fund a piece of his profits. Not that they become partners in his business, but that they get to use his likeness And you know, his idea for promotional purposes, and that if they're named in a suit having to do with him, he'll go ahead and pay the legal fees to defend himself and them. Come on now. Come on now. This is extremely dangerous, like dangerous. And I'm going to get into why when I talk about who is against this ruling. The implications of this, So Fearless Fund did mount a defense, and the two white judges on the Bush appointee judges on the 11th Circuit rejected all of their defenses. Fearless Fund actually has a group of lawyers from different organizations defending them, because a lot of organizations are vested in seeing Fearless Fund prevail in this case because of the implications of the case. So I want to get into what some of their defenses were and why the 11th Circuit Court rejected them, because the implications are wide. So their first defense was, this is affirmative action. So the Civil Rights Act of 1964 made it legal to give some kind of preference to African Americans to remedy past discrimination. It can be shown statistically that fewer than 2% of African American business women owners get, or that African American business women owners get less than 2% of the venture capital that is out there. Like, that's quantifiable. And that this has been going on for a long time. So their defense is, this is affirmative action to remedy that past harm. The 11th Circuit Court rejected that, saying the majority held that valid affirmative action plans cannot create an absolute bar to the advancement of non-Black business owners. Let me say that again. Create an absolute bar to the advancement of non-Black business owners. So non-Black business owners are getting 98% of the venture capital that is available. But those $25,000 grants that Fearless Fund is handing out is creating a absolute bar to the advancement of non-Black business owners, non-Black applicants. I'm just going to leave that there. The majority specifically rejected the idea that it was acceptable for Fearless Fund to make race-based decisions because non-Black women could get funding for their businesses elsewhere, calling that argument anathema to the principles that underlie all anti-discrimination provisions. But the truth is, non-Black women can get VC funding elsewhere. It's Black women that aren't getting VC funding, that are only getting 2% of it. Non-Black women are able to go other places. I am not saying that women who are white are not at a disadvantage when it comes to VC funding. I'm not saying that, because that wouldn't be true either. But I am saying that the harm in the past towards African Americans when it comes to venture capital is provable. It's quantifiable. And that saying that there's an absolute bar to the advancement of non-Black applicants, like, I don't feel it's absolute at all. And I don't feel that saying non-Black women can get their funding for their businesses elsewhere is in any way untrue. Because when white business owner ladies don't get VC funding, they can tap into family networks. They can tap into friendship circle networks because the disparity, the wealth gap between white America and Black America is so large that a white person can be like, well, I can't get the money from VC, but I could probably get it from family members. Am I saying that every white business owner could do that? No, I'm not. But remember I told you the level that you have to be at to even be an applicant? This is not, little Miss White Lady who owns a hair salon and wants to get a mobile truck so that she can cut hair mobily for older or disabled people. This is not her. These are ladies at a high level of business who need capital to expand what they have already built up. Ladies at that level really can tap into other networks if they're unable to capture some of that VC money. So that is, for them to deny that, I just don't even know what to say. I can understand why Judge Wilson was apoplectic. I can understand. So that was their affirmative action defense, and it was rejected. I want to come back and add one more thing about their affirmative action defense. This is the scary part that you need to pay attention to. After expressly flagging as an open question whether the longstanding recognition of an affirmative action defense to charges of discrimination in violation of Civil Code 1981 and of the Civil Rights Act remains good law following the recent decision by the Supreme Court against affirmative action. So the 11th Circuit is like, even if you had a valid affirmative action defense, that was old law. New law is bringing into question whether or not anybody, not just you, anybody can bring an affirmative action defense. So they're looking to tear down affirmative action defenses in lieu of the recent Supreme Court decision all around. Not just, Fearless Fund's affirmative action defense was not that really good, but they're saying that whole line of defense may need to be wiped off the map. The other reason that the 11th Circuit Court rejected the Fearless Fund's affirmative action defense is they are applying the affirmative action defense to employment discrimination. However, the Fearless Fund is a nonprofit organization that does grants. So the 11th Circuit is indicating that they may say, you know what, you can't use the affirmative action defense when you're doing grants. Whoo-wee. So scholarships, the big black churches that have housing funds to help black people become homeowners, all this kind of nonprofit giving may be in jeopardy if it's mission driven and the mission is advancing a certain race. That's a little bit scary, right? And that even goes to the contract part too, because I remember when I was living in Oakland, there was a church that had a housing fund, and it was a black church, and the housing fund was meant to help African American couples buy a home. And it was called like Building Black Wealth or whatever. You can imagine what it was called. The couple signed a contract too. The contract said, you, the couple that's getting the grant, have to occupy the home, not rent it. And if you are not living in the home for at least 5 years, or if you sell the home in fewer than 5 years, you have to pay us the grant money back. That's a contract. So will churches that help build black wealth be able to continue their mission? And then scholarships. There's Korean churches that have scholarships for Korean students. There's Jewish synagogues that have scholarships for Jewish students. There's that type of thing. They often have to sign a contract too. So my church, First Congregational Church of Long Beach, gives out tiny scholarships, like $250 to a group of students to help you pay for your books or whatever. And you do have to sign a waiver saying that the church can use your image on its website and in its marketing. Hey, we give scholarships, blah blah blah. That's like exactly what Fearless Fund is doing, not the indemnification part, but the whole use of your image. So will that be able to, stuff like that be able to continue? And then a lot of the ethnic churches, be they, it's an ethnicity and a church, like a synagogue or a Muslim mosque, or what comes to mind, because I'm in Southern California, is Korean Christian churches. They give scholarships much bigger, right? Sometimes the student has to sign a contract and it says, if you drop out, right? If you take this money and then you don't complete your degree, you have to give the money back. That sounds very much like a contract, the way 11th Circuit is defining it. So is that type of giving going to be able to continue? It's questionable. This is why I say this is so dangerous. It has implications far beyond Fearless Fund and VC money. To say that a nonprofit may not be able to use an affirmative action defense, or to say that, the free speech defense is not available either, when money is speech, it has implications. So why exactly did the 11th Circuit Court say that the Fearless Fund couldn't mount a First Amendment defense if money is speech? So they said the First Amendment does not protect the very act of discriminating on the basis of race. Fearless Fund's position that the First Amendment protects a similarly categorical race-based exclusion risks sowing the seeds of anti-discrimination law's demise. If Fearless Fund is allowed to do what it wants to do, a white business owner could fire all his black employees to communicate his bigoted views. Let me read that again. If it recognized a First Amendment right to only offer grants to black women, it would have to allow a racist white business owner to fire all his black employees to communicate his bigoted views. Now, didn't we just have a Supreme Court case in which a baker said, I refuse to bake a cake for a gay wedding because my free speech allows me to express my bigoted views by not serving certain customers in my open to the public establishment, because that's my self-expression, that's my First Amendment right. Didn't we just have that case? So listen, I'm not a legal scholar, so I welcome people who are lawyers or who are studying law to explain to me how we could have that Baker case and then how the 11th Circuit Court could say what it just said. Okay, so for the Fearless Fund, the case is going forward, and in the meantime, the Fearless Fund is not allowed to give out grants because the 11th Circuit Court granted an injunction. The Hello Alice case was dismissed. So I want to go over the points that the Hello Alice case made in its asking the U.S. District Court of the Northern District of Ohio, Eastern Division, for a dismissal, because that dismissal was granted in 2024, February. And it was granted by Judge Patricia Gahan, who was appointed by Bill Clinton. Just saying. So let's talk about what their 5 points. So regarding the arguments that Hello Alice made when they asked the court to dismiss the case that was being brought against them. The first point is there was a plaintiff, right? The plaintiff was a white truck driver a guy who, no, yeah, he was a truck driver, like he owned a trucking company, but it was like his truck, right? Small businessman. And he wanted to get another truck so that he could expand his business or get a better truck or whatever. So he started filling out the application, but then when he saw that it was for people of color, he stopped. So their first argument is, hey, the plaintiff didn't prove that he would have gotten the grant even if the grant was race neutral. Like he didn't prove that. He didn't submit evidence showing that he met all the criteria. So dismiss. The second argument was, this grant isn't asking anybody for any consideration. Consideration is a legal word for like, I give you something, you give me something. So there is no contract. So we're not violating contract law because there is no contract. I kind of find it hard to believe that the people who get the grants don't at least have to sign a waiver saying that their image can be used, because Hello Alice does profile past winners and how the money helped them grow their business. So I don't know how that works. Usually when you do that in marketing material, you have to get the permission of the person, but I don't know. In any case, their claim was that there was no contract. Their third argument was, look, even if, judge, you look at this and you say, no, there is a contract, it doesn't belong in the U.S. District Court for Northern District of Ohio Eastern Division anyway. It belongs in a California court because we're based in the Bay Area. So this whole case should be moved if you don't give the dismissal. So that was point number 3. Why would they say something like that? Because they know the judges in the California courts are going to look more favorably on their arguments because elections have consequences. The fourth argument that they made was very interesting. It was a First Amendment argument. It was the same First Amendment argument that the Fearless Fund made, that the 11th Circuit Court rejected. But in this case, when it was just before one judge who happened to be a woman and happened to be appointed by Bill Clinton, Okay, the fifth argument was the exact same argument that the Fearless Fund made, which is this is an affirmative action program to remedy obvious past harms to people of color, LGBTQ people, disabled people, so forth. Exact same argument. Now, Judge Patricia Gahan ruled for dismissal, but not on the meat of their arguments. She ruled for dismissal saying, listen, truck driver dude, you really didn't prove you don't have standing because you didn't show evidence. You did not argue that you would have gotten the grant even if it had been race neutral. So without that, you don't have standing. So I'm dismissing this case based on you, the plaintiff, not having standing. Now, in the Fearless Fund case, the Fearless Fund is being sued by one right-wing group, and the Hello Alice is being sued by a completely different right-wing group. And I'm going to get into who those groups are. But what the AAER has done in the past when they've been rejected based on standing is they have solicited for plaintiffs who would face up to a standing challenge. So the right-wing group that is suing Hello Alice has already said they're going to appeal this dismissal. And how much you want to bet they're going to find some plaintiff somewhere who can stand up to a standing challenge. So we'll see what happens, but mark my words. So what were the consequences of the Hello Alice suit, even though it got dismissed? As I stated, that grant that they were administering for which they got sued was to give a business owner money to buy a vehicle that was going to help them grow their business. that was not Hello Alice's grant. They were managing the grant for Progressive. So when the suit happened, even though it got dismissed, Progressive said, for its part, in its own court filings, that it does not plan to sponsor grants in the future that include race or other demographic-based eligibility criteria. So they're backing out of granting money specifically to help previously disadvantaged groups. And then Hello Alice had to pay lawyers to defend this suit, and it cut into their budget so bad that they had to fire 69% of their workforce. So people lost jobs. People who wanted to work for a mission-driven company that was helping disadvantaged business owners get a come up lost their jobs. And this is exactly what these right-wing legal groups that are suing want. They want to scare away investors from giving money to the grants, and they want to hobble the organizations that are giving the grants. So as you can imagine, there are a lot of organizations that are very invested in how these lawsuits progress, in how the appeal against the dismissal of the Hello Alice lawsuit progresses, and in how the Fearless Fund lawsuit progresses. Like, I'm sure you saw in the paper that all these VCs signed a letter saying, no, we support Fearless Fund, and we definitely need to build up Black businesses. It's good for the economy, blah, 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 all this. But you might be surprised to learn that there are conservative groups that want the Fearless Fund to prevail as well. In the Journal of Philanthropy, is that what it's called? I don't want to lie to you. It's called the Chronicle of Philanthropy. Howard Hussock, who's the senior fellow at the right-wing American Enterprise Institute, wrote an article in favor of Fearless Fund. And what he said was, the courts don't even need to be looking at whether or not this is a contract. What they need to be looking at is the fact that a non-profit organization has money and has the right to give that money to who they feel like it. That is their First Amendment right. Even if I don't agree with their mission is clearly stated, and they are applying their money as speech towards their mission. And if they can't do that, he didn't say this in the article, but he said everybody in the philanthropic world needs to be concerned if Fearless Fund, if the courts rule against Fearless Fund. Now, I already mentioned the, Korean churches, the Jewish churches, the Black churches with the wealth funds. He's absolutely correct. He's talking about conservative groups and their conservative causes. That's what he doesn't want touched. But his point is spot on. And the other thing is, conservatives, American Enterprise Institute especially, does not want to hear anything about capital not being able to do what capital wants to do. They don't want to hear anybody telling them, I can't do what I want with my money. They don't want to hear that. So, of course, he was going to come out against this. But the American Enterprise Institute is no small fry when it comes to the conservative movement. So for him to write this article, it's meaningful. So who are these right-wing legal organizations that are suing Hello Alice and Fearless Fund, and who is behind them? Hello Alice was sued by America First Legal, which was formed by Stephen Miller. I'm sure you're all familiar with Stephen Miller, but just in case you're not, let us review. He was a Trump advisor. He wrote that terrifying American Carnage speech. He and Jeff Sessions came up with the idea of separating families at the border and that whole bit of evil. And he's the one who is heading up the part of the 2025 plan that calls for mass deportations. So that's him. He's just a no good person. Also, a huge election denier. Let me tell you who else is on the America First legal team running it is Mark Meadows. So Mark Meadows was instrumental in helping Trump plan his coup of staying in office even after Biden won the 2020 election. He was so instrumental in it that he was indicted in the Georgia case with Fannie, and he faces criminal charges in that. In addition to he was going to be charged in the DC election interference case, but he got immunity. And when he was in front of the grand jury, because if you get immunity, you got to talk, he said that Biden won. He said, obviously, we didn't win. So now his book publisher is suing him. He had a book called, what was it called? The Chief's Chief. And at its core was the key claim that Trump really won the election. So when he got in front of a grand jury and said, well, obviously we didn't win, which he had to do in order for his immunity, because he would have been indicted otherwise, and was already indicted in Georgia, the book publisher is like, how are we going to sell the book now? You just completely contradicted what your main point was in the book, so we're going to sue you. So that's him. He's the one that the little brown-haired girl, what was her name? Cassidy came and talked about all the evil he was doing behind the scenes to keep Trump in office, and it was the biggest part of the January 6th hearings. That was him. Also on the board is former acting assistant attorney general Matthew Whitaker. Whitaker was the one who refused to recuse himself from overseeing the Mueller investigation and thwarted the Mueller investigation at every turn. He's also a board member on a company that scammed investors so bad that they ultimately had to pay the federal government $26 million in fines. So these are the best people that are on the America First Legal Fund. How are these clowns being so successful? These clowns are being so successful because they get in front of these judges, these specific judges. And I'm going to talk about that in a minute. But let me also tell you who is the American Alliance for Equal Rights and who's behind that. That's Ed Blum. Now, Ed Blum lost a congressional election in the early 90s in Texas. And instead of being like, I lost, he turned around and sued the state of Texas, saying that the redistricting discriminated in favor of African Americans and Latinos, and that's why he didn't win. Because the white guy couldn't win because the districts were drawn to favor African Americans and Latinos. He was successful in that case, but it only applied to particular districts in Texas. But then he turned around, took that success, took that as a template, and he was the one who was instrumental in the Shelby versus Holder case, which completely gutted the Voting Rights Act at the Supreme Court level. So this is this little devil that's doing that. And he is on a mission to dismantle affirmative action all over everywhere. So I can't say this enough. Elections have consequences. Do you see this guy, Judge Reed O'Connor? He's a Bush appointee, and he is the one that made it so that the America First Legal Fund with Stephen Miller was able to even get the first victory in the Hello Alice case. So this guy, Judge Reed O'Connor, has been on a mission to overturn Obamacare since Obamacare was passed. All the Obamacare, all the overturned Obamacare lawsuits went through his court. They were overturned. His judgments were overturned at a higher level, but he always voted for the party that wanted to overturn Obamacare. That's going to be his sick legacy. Do you remember Judge Matthew Kacsmaryk? He's the one that was on the mifepristone case and said, oh, you know what? The FDA did that all wrong, and it doesn't matter that mifepristone has been being used safely for all this time. The FDA never should have approved it, and it needs to be taken off the shelf and reevaluated. That was him. Well, he's also the one that was overseeing the first part of the case for the AARE against the Fearless Fund. This guy is a high-wing judge appointed by Trump. The other guy was appointed by George Bush. I'm leaving these two spots blank because more lawsuits are coming to help dismantle affirmative action, to help keep people of color from having to come up, Black people especially. And we're going to see who the judges are in these cases and how that reflects what the judgments are. I'm telling you, even if you don't like Biden, you need to vote for him because he appoints judges. And look at the havoc these GOP appointed judges are wreaking right now. All right, so that's it with Fearless Fun and Hello Alice. Subscribe if you want to. If you don't. I am going to keep making this content because I really want to express my views. But give a thumbs up if you got something out of it. Please remember to mark that thumbs up button. All right, and I am working on a video about housing. It's going to be a little more in depth, so I might not have a video next week. Okay, looking forward to hearing from you in the comments.